Hello and welcome to another informative Connectionology webinar. Thank you so much for joining us today. Your host, as always, Executive Director of Connectionology, Ginger Jarek.
Hi, everybody. Welcome. Oh my gosh, I hope you're having a wonderful day. We are so excited. We have an amazing webinar planned for you today. And we're so excited to have HMR doing this in conjunction with Connectionology. I know you're going to have a lot of great questions, so please write them in, put them in the Q&A box down at the bottom of your screen. Kyle is also going to keep an eye on the chat box as well. Before we get started, though, I want to quickly introduce one of our amazing partners. His name is Leon Branham, and he is with Fast Funds. Many of you guys probably already know him because he's been a huge fixture all across the United States for probably the last 15 years, and he knows just about everybody, so he's a great resource. And it's so wonderful to see you today, Leon.
Hey, Ginger, how are you?
Wonderful. And look, we got Kyle today, we got Hugo. It's going to be a great webinar.
Looking forward to it. Thanks for having me on today. I'll just share my screen real quick. And for those who aren't familiar with who Fast Funds are, we are, let me just get in there. We're one of the original litigation funding companies that started the industry nearly 25 years ago. We provide non-recourse attorney and plaintiff funding solutions on an individual case basis. As many plaintiff attorneys know, it's like a financial David versus Goliath, where the plaintiff attorneys must cover their own expenses on every case up front and on a contingent basis. And meanwhile, the defense has their fees and expenses covered by deep-pocketed insurance companies. So this creates a culture where the defense will routinely delay case resolution and attempt to outspend the plaintiff attorney as a tactic for your client to accept less than their case is worth. So what do attorneys do, or plaintiff attorneys do now when they're competing against a fully funded defense? Many attorneys will self-fund one case at a time, but their resources are, right, everyone's resources are somewhat limited. What are they doing about their other cases they're not funding at the time? And what do they do when overhead and marketing comes up? Many attorneys will refer cases out, but when they don't cover their own expenses, they're giving up, anywhere from an additional 40 to 75% of the fee that they would normally be able to recover. Some attorneys will try to stretch their dollars using less expensive experts, but as the saying goes, when you pay peanuts, you get monkeys, and good experts are worth their weight in gold. And many attorneys, logically, will go to a bank to see if they can, get a loan. But banks will give you an umbrella when it's sunny outside and ask for it back when it rains, meaning they're a highly regulated industry and they're unable to value what's most important to plaintiff attorneys, which is their assets, which are their cases, because they're on a contingent basis. And unfortunately, sometimes, you just have to do what you do. And many times attorneys will accept less than what their case is worth in order to live to fight another day. Well, at Fast Funds, we've developed a solution, and there's a better way. We've got a unique funding product for plaintiff attorneys to help cover expenses on individual cases on a non-recourse basis. That means there's no personal guarantee, there's no lien on your portfolio of cases or your attorney fees. And if your case is lost, you don't repay the advance. That allows you to not only get the best experts, but allows you to move more cases along now by getting the experts that you need where they're most needed, whether it's to prove liability or to prove damages or maybe both. So we don't tell you how to work your cases. We're just here to kind of be a financial support. So you decide what your cases need and which experts to use. It's your choice. We've worked with many attorneys and many experts, and the attorneys keep telling us once they've engaged the right experts, their case value increases and the time it takes to resolve in litigation decreases because you've really kind of worked up your case and proved it. Looking forward to this great webinar. There's my contact information. I'll put it in the chat box. If you have any questions, please don't hesitate to give me a call. Thank you so much.
Absolutely. Thank you so much, Leon. And I know you live in New Jersey, but you work with clients all over the country. You guys have a really quick turnaround, and we're just so appreciative for everything that you do there, and for supporting us here at Connectionology. Thank you so much for everything.
Absolutely. Thank you.
All right, so you guys call Leon and definitely save his information because you might need it later. So anyway, we're going to go ahead and get into the presentation, but first I want to go ahead and introduce everybody to Kyle Kinberger with HMR. I'm sure that you guys probably already know him, but in case you don't, he's actually the National Sales Manager at HMR, and he's helped hundreds of attorneys get the funding that they need for their clients' medical care. So currently he oversees the daily operation of the business in probably over 39 states now. I know that he lives in New Orleans, but again, they work with everybody all over. And he's been with HMR since 2012, but he's been in the medical funding space for probably more than 10 years now. He's been an industry leader in the medical funding for the last 8 years, and he continues to expand the thousands of medical providers and attorneys that they work with nationwide. So he's helped fund thousands of plaintiffs' medical care across the personal injury spectrum, with a primary concentration in funding catastrophic injury cases for plaintiffs who are uninsured. So they do a lot of great work over there. I absolutely love their team, and so does John Romano. They work with many different specialty providers that include orthopedic and neurosurgeons, as well as interventional pain management specialists and inpatient and outpatient traumatic brain injury centers. They're one of the only companies in the country who's willing to fund these large brain injury cases for plaintiffs involved in litigation. And so I would definitely recommend that you guys call them or ask Kyle some questions later on if you have anything that you'd like to find out more about. So we're very lucky. We're going to have some fun. I can't wait. I'm happy to have the whole group back together again. If you'd like to watch some of these previous TBI webinars, you can go to the HMR website and they've got them listed there. You can also go to the Connectionology YouTube page and check out some of our webinars as well. So enjoy the webinar today, you guys. Thank you so much for watching. I'm going to go ahead and hand it over to Kyle.
Hey, thanks, Ginger. We appreciate it. Yeah, thank you so much for everybody for tuning in. I know you're seeing some familiar faces. We've got Hugo Chanez with Mitchell Sanchez out of New Orleans, who's got a lot of great information that we're going to get into today. The format we're going to run today is really going to be an interactive discussion. Hugo is going to be, getting into a lot of depth on the topic today. And so what we're going to encourage everybody to do is, as you think of questions, definitely ask them. We're going to monitor the chat and the Q&A, and we'll ask the questions as we go. That way we don't kind of pile up at the end. But I think just kind of jumping into it, anybody who's tuned in before, you've seen a few webinar installments where we've talked about primarily traumatic brain injury cases, really getting into what we're looking for, how certain providers, I think we've had one with Dr. Travis Schneider, who's a neuroradiologist, on what he's looking for when he sees a patient who's got a possible TBI, and kind of what he's trying to identify on the films and his interpretation of that. And so kind of taking you from there and getting things identified and then working those cases up to get the people the treatment they need. Really what kind of comes to the forefront is the back end of these cases in the litigation process. And that's a lot of what's going to be discussed today. Today's installment is how to use the discovery process to sideline the defense's TBI experts. And I know that we've got a fair amount of ground to cover. So with that, I'm going to go ahead and turn it over to Hugo Chanez. Hugo, like I said, is a partner at Mitchell Sanchez. He's based out of New Orleans. He is a fellow of the American Board of Trial Advocates program at Harvard Law. He's a past member of the National Trial Lawyers Top 40 Under 40, as well as a member of America's Top 100 High Stakes Litigators. So with that, we'll jump right into it. Hugo, I'll turn it over to you, bud.
Thank you, Kyle. You're far too kind, as always. So one of the things we were talking about a while back is, well, when you're proving your TBI case, you have to get the care and the experts to be able to prove your client has a case. But when it comes to traumatic brain injury litigation, and really anytime a big catastrophic injury litigation, the defense is going to get their own experts as well. And this may shock you, but their opinions are going to be completely opposite to your own experts' opinions. In fact, in traumatic brain injury, most of the times they're going to say, it's not a brain injury. There are no cognitive deficits. If they are, they're related to something else. If there's a neuroimaging expert, he's going to say, I don't see anything on the film, as your expert says. And if you do enough of brain injury litigation, you're going to run across the same cast of characters, depending on what part of the country you're in. Now, I have a national practice, so I do cases all over the country. So I'm kind of going to focus a little bit on using the federal rules, because most states model their discovery procedure and evidence rules based on that. Also, I'm based in Louisiana. But something interesting that happens is most lawyers, especially on the plaintiff side, are a little bit afraid of discovery, don't know how to use it to the full extent possible, and therefore you sort of leave doors open for the defense to be able to attack you at trial. One of the things I was always taught is a case settles for trial value when they know they got no way out. And what I'm going to talk about today is one of the ways you set your case up so that the defense experts are completely sidelined. And what I mean by sidelined is they're going to have to agree that your client has the injuries your experts say they do, and you're going to be able to show to the jury that they have a bias and incentive to always testify for the defense. So first of all, destroy credibility. Second of all, use their own tools, their own equipment, their own literature to prove you have a case. Now, to get there, it's going to take a little bit of paperwork. And that is why I think a lot of people don't do this. But if you do it well and you take the time ahead of time, you will see a huge change of value in your case. For my defense lawyers who like to tune into these and later on use webinars against me, I welcome you tuning in. You've seen all this, it's public record. And we're going to go through all the defenses that you've given me before and how courts have actually rejected them and how I've defeated them. So one of the things we have to come up with is you get to a point in litigation in which the defense has to disclose their experts. If it's brain injury, they're likely to get a neurologist. They're likely to get a neuropsychologist. And they are likely to get a neuroradiologist, amongst others. But that is a trilogy of defenses you're going to get on a TBI case. The minute they are disclosed and the minute you have expert reports, you don't want to do this too soon, you are going to have to issue a subpoena to them. And it is going to have to be a comprehensive subpoena. And that is what is going to build the case for you to be able to get the documents you need. If you want to be able to, at the end, come in and say, look, the defense expert is paid for and bought for advocate, either to the court or to the jury. So let me go ahead and show you a sample of what I am talking about and what my firm uses, because I think it is very beneficial. And if you do brain injury litigation, you've probably seen some of these doctors who are going to try to hide the names. So this is what I always attach. It's called an Exhibit A. And the reason why is because the stock motion, whoever they use, I go ahead and I just change the names on it. And it's divided into 7 sections. The first one, you have to be very specific because, as you well know, defense experts do this for a living. They're very well versed, almost as well versed as lawyers, at avoiding subpoenas, at avoiding production of documents, and avoiding questions. So you got to go into a lot of detail. And we ask for 1, file materials, notes, interview forms, intake forms, listings of any imaging they have, okay? Any documents they receive from the defense. And it's not a blanket, tell me everything you received. We go and we list specifically everything we can think of that they could have received. And the reason why is we're going to walk into a deposition after they produce this, and we had a huge fight on it, and go through it and figure out where all the lies are. Anything they relied on for their opinions and conclusions, this is critical because they could get 20 bankers' boxes of documents. If it's not relied upon for their opinions and conclusions, it doesn't matter. It doesn't count. But anything else that they may have not received from the defense, but it's their literature, their textbooks, their articles they're writing, their research they have, that is what you want to be able to get here. And point number 3 is always going to be a fight. 4, forensic work. We know these gentlemen and ladies testify for a living. They are forensic experts. They're not treating physicians. There's a big distinction between the two. When you do this for a living, you're going to make money off it, and they do very well. But because of that, they've done their IMEs. We want to see their prior IMEs. And the reason why you want to see those prior IMEs is simple. I almost can guarantee you 90% of them are going to be cut and paste jobs. They're simply going to change the name of the plaintiff every time. In fact, if you go through enough of them, you'll find that they'll make mistakes and even the names won't be redacted properly. And another one you got to have a fight on, forensic work, financial documentation. And this is what allows you to prove that their opinions are bought and paid for the defense, because they make a living off of this. As I tell you right now, 3, 4, and 5 are always going to be a fight. Do not assume or expect you are going to get this just by saying the subpoena. You are going to have to go to court and fight this out. The defense will do anything in their power to get you, to stop you from getting these documents. That should tell you how powerful this evidence is, that they're going to fight you that bad. They'll give you the file. They'll give you a list of cases that testified in the last 5 years. Their rule, federal rule disclosures, not a problem. Once you get to the specifics, they don't want to ever give you that because it destroys their case.
Hugo, let me ask you a question real quick. When you're talking about financial bias and, as it relates to maybe a defense expert, and you talk about kind of the fight, can you get a little bit more granular there as to what's a common tactic that you see and maybe how you approach that defense from opposing counsel?
Correct. So let's start with the federal courts, state courts have all recognized that the amount of money that an expert makes from litigation is relevant to be able to prove their bias. Under federal rules of evidence, you can bring that in order to show a jury that they have a bias against your client. Now, federal rules already require you to disclose any case you've been in the last 5 years. That's your standard disclosures. And that's what experts will give you. And the federal rules also require you to have a statement by your expert on the defense side that says, I charged this much per hour and I was compensated this much for doing the report. Well, that is where the defense wants to leave things, saying, Mr. Expert, you were paid $100 and you charged $10 an hour. And they don't want to give you more than that because they want to tell the jury, listen, their expert gets paid, our expert gets paid, everybody gets paid. It's what happens. Here's the problem. And as courts have recognized, experts, to qualify as an expert, are highly intelligent, highly educated, and can have this aura of the good doctor who's simply trying to give regular opinions and mislead a jury. What you want to be able to do is show that this doctor makes millions of dollars off of the same type of work every single time for the same type of defendants, and that this isn't this one time he's been on a case. He's not making $100. He's making $100 in this case, but he's got 200 other cases already in line. He is now making $2,000, $200,000. That is what you want to be able to do. So when you send this, the first thing they're going to do is they're going to object. Well, first thing they're going to do is they're going to ignore your subpoena. And then when you push them, they're going to go to court. They're going to move to quash it. And their argument regarding finances is going to be this: tax returns are private in nature. We cannot produce that to you. We will be violating federal law if that is the case. They're confidential. They're going to tell the judge, crying and screaming, Your Honor, if this was the case, this doctor's got private practices, got other side businesses, he can disclose all that. His information can be on the public. You can't allow this to happen. This is outrageous. It's extensive. It's all lies, if you're careful on how to word it. So first of all, you can always redact the private information from your tax return. What you want to do is when you go to court, first of all, you're going to cite the cases that have allowed it. And all those cases say tax returns are discoverable. It's funny how it's not confidential when they want your plaintiff's tax returns, but when you want their defense expert's tax returns, it's a different story. As long as the personal information is redacted. Bottom line is, what you want this for is to show the jury the bias, not for no other reason. We don't care if the doctor has other side business or deals. We just want to be able to prove to the jury, well, we already know that this gentleman makes millions of dollars simply testifying for defenses. So you ask that all the personal information be redacted. And you can, in lieu of a tax return, you can ask the judge to say, Judge, how about an affidavit from their accountant telling me what the net and gross income they make from litigation every year for the last 5 years? Once you do that, any defense they have that this is personal in nature and it is confidential goes out the window. So does that answer your question, Kyle?
Yeah, it does. I appreciate it. We actually had a couple more questions pop up. If you want to try to knock them out real quick.
You want to read them?
Yeah, so we have a question. It says, is there an issue with HIPAA and getting the IMEs? If so, how is this handled?
That's actually a really good question, because you know how these crybabies are, especially the ones that are, probably watching this webinar, and we will just argue this recently. So yes, when it comes to IMEs, first defense, Judge, it's a HIPAA violation. They can't disclose that information. And some judges get concerned about that. And they're going to come to you and say, Counselor, how do you address that? How do you deal with the fact that this is a HIPAA violation? And this we have to go back to, first of all, there's plenty of case law out there that says it's not a HIPAA violation and you can produce it. But some judges want to go a little bit deeper. And this is where you go into it. HIPAA only applies to a covered entity. And you can look at the HIPAA Privacy Rule Act. Okay, so the first question you have to ask, is a litigation expert a covered entity? If it's not, HIPAA doesn't apply. If it is, well, can it still be produced with violating HIPAA? So I can tell you, there's a series of decisions that say that an expert is not a covered entity. But number two, let's assume that they are. Well, once we get to the analysis, it's still discoverable. And here's how you get around it. Section 164.514A of the HIPAA rules, okay, say you can disclose information so long, okay, as the privacy concerns that are involved in HIPAA are addressed, okay? So then you go to what's called safe harbor provision, and it's 164.514B2. Just memorize these. You're going to have to cite these to a federal judge one day. And say that is the safe harbor provision. It says, if you remove the identifiers in the records, it is no longer a HIPAA violation to produce medical information. So you remove the name, geography, zip code, phone number. Once those elements are out, these can be produced. So what you do is say, Your Honor, and your subpoena has to include this, we want them redacted. Once those items are redacted, it is no longer a HIPAA violation, assuming the expert is even a covered entity, which I can promise you they're not. But if they want to make that argument, you can stand up in front of the judge and say, well, Judge, here's why they're wrong. Because the HIPAA rules say this. Under this section, we can produce them as long as they're addressed properly. And that is a safe harbor provision. Once you've redacted that, it is completely allowable to be produced. And I will tell you, there are a series of cases out there, and even in federal court, which have ordered experts to produce 5 years of IMEs with the names redacted. And that is how you get those IMEs.
Gotcha. Thank you. Last question before we let you jump back into it. It says, how do you counter the defense argument that your medical expert is also paid for and biased, especially if your medical expert has been used by you more than once.
Okay, so there's a couple of different ways, and I need a bit more information as to how I would counter that. But there's a clear distinction on this. A treating physician is different than forensic expert, and that is something you got to set the tone and control narrative early on. The defense is going to want to argue, well, listen, experts are experts. Everybody's got to do this. There's a big difference between a ER physician who gets a patient who's involved in a car wreck or in a catastrophic injury, treats them, and now is testifying in court, and one that makes a living off of testifying in court. So the way you would counter that is by saying they are not forensic physicians. They are treating physicians. These are the people who treat my client. There's a physician-patient relationship with them that does not exist between the expert and my client. And I promise you, any defense, IME expert, you go, you depose them, say, is he your patient? First they say, absolutely not, hell no. Why? They don't want to get some medical malpractice. And that is a clear distinction between them. So yes, are they going to ask your expert, how many times have you worked for this firm? Yes. Are they going to ask him, how many times you testify for this firm? And your expert's probably going to say, well, listen, I don't testify for a firm. I just testify. It just happens that I work in the ER, or I am the best neuroradiologist there is around here. And I get a lot of these cases because they're complicated cases and they need a really good doctor. That's how you do it. And I'll tell you that if you're on the plaintiff side, it's a little bit easier because there are plenty of times where this same expert has probably said, your client doesn't have the injury. And that's fine. On the defense side, their expert has never said the injury is there. So that's how you would counteract it.
I appreciate it. And I see kind of the undertone in the question, hey, if you're, laser focused on pointing out that there's financial bias, with their defense expert, could that not in turn be turned around on you and become problematic at some point without the appropriate, defense? So.
And I'll tell you something else about this, Kyle. What you're going to find when you do a lot of this brain injury litigation is the defense experts are used tenfold more than what the plaintiff physicians are used. Whereas, there may be a physician that a lot of your clients go to. The defense, that's your office, your firm. Defense firms have almost like a database. And they have we got a brain injury case. Who does everybody else get? This one, and this one. Okay, get me all three. And often enough, these guys will come with a package deal. If you look at their medical literature, they write articles together.
I like it. Well, and I know that we've kind of been talking about, financial bias, but, some of kind of what we're starting to lead into here is, kind of defense-focused testimony and kind of how that plays into it. So.
Yeah. So one of the issues that we're going to get into is you're going to fight on this. You're going to fight on the literature. So you're going to get a beautiful defense expert report that's going to go through everything and it's going to say your client's not injured, your client is fine. These issues, especially when you deal with mild brain injury, 90% of them resolve in 90 days. Anything that lingers from on that is secondary gain, and they have articles on this. And that is why it's so important where you're going to say, give me every single piece of literature upon which you rely for your opinions in your report. They're going to give you some literature. You want to push the issue. You want every single piece of literature. And let me tell you, it's going to be a lot because their tactic is after they lose this argument, they're going to come in and going to try to overwhelm you. They're going to give you 20 bankers boxes of medical literature. None of them are going to be cited in the report, but that shows you what the tactic is too. So they're going to want to say, Judge, we've cited the literature in our report. They can go get it. Or as it was commonly said in an argument that we had recently in court was, well, Judge, they can Google that stuff. Well, telling me what the article name is not sufficient. There's different editions. There are different journals. And what you want is the actual article they relied upon. And here's what they're going to come back and say to you. Judge, we can't produce all the articles my expert relied upon because That is a violation of copyright law. When you get that argument, be prepared. It's not a violation of copyright law, but of course you can't just come in and say, nah, judge. Plenty of courts have, disclosed this, but if the judge wants to go deeper, the answer lies in section 107 to 118 of the Copyright Act of 1976. It's called the fair use section. And it is not a violation of copyright law to use an article, even if it's, copyrighted, for criticism, comment, news, reporting, teaching, scholarship, or research. If they are drafting opinions based on this article, that is clearly research. So it's the fair use doctrine. When they come up with that, because they love saying it violates copyrights, we can't produce all this stuff. Yes, they can in the fair use doctrine. So just know it's section 107 to 118 of the Copyright Act of 1976. Once you get these articles, and this is the real treasure trove, because I can almost guarantee you, those articles, if you read them in depth, are not going to say what the defense expert says they say. Medical literature is like case law. You can find a little blurb in a case that says exactly what you want to say. It might be the dissent, it might be the concurring opinion, or it might be a analogy, but you can find it. Medical literature is the same way. So you will see they will take snippets of the literature and they will take them out of context. Because, for example, in brain injury, the first thing the neurologist is going to say is, it's not a brain injury. Oh, sorry, the neuroradiologist, whatever you see on the brain, that's not traumatic injury. That's diabetes. That's smoking. That's alcohol use. That's medication abuse. And when you ask them on point what they rely on for that position, they're going to say the medical literature. Like there's some holy gospel out there. Well, what medical literature do you rely upon? If you're in a deposition and you don't have all this information on you, they're going to be able to just say the medical literature. I don't know the medical literature. I don't know. I can't think right now, but I know there's literature that says that. Well, again, this is why you do this ahead of time. This is why you don't take the deposition until you have this literature. Because you're going to say, oh, well, that's not a traumatic brain injury on the brain. That is smoking, and I'm basing it on the Rotterdam study. Well, I've seen the Rotterdam study. First of all, if you've seen that study, you'll realize that the control group there was heavily tested. Then you can ask questions to their expert as in, okay, so in the Rotterdam study, which is a longitudinal study anyway, what was the amount of nicotine it consumed? The study is very specific as to what it was. Well, you've also asked any information they have on your plaintiff. Tell me where it shows in your file that they consumed that amount of nicotine. Well, I don't know. Exactly. You don't know. Same thing with alcoholism. Oh, well, alcoholism can cause it. Okay. Show me that study. Yes. Long-term, 20 years, 4 drinks or more. Show me the evidence where my client has been drinking for 20 years, 4 drinks or more per day. You don't have that. Those are the kind of keys you need to be able to get. The only way you get that is if you get the literature far in advance, you read it, you know what it's about. So when they come in and say the medical literature, you can counteract that with which literature? And they'll say, oh, the literature. And you can have your 20 bankers boxes there and say, well, here's your boxes, doctor. Show me which one.
You got a couple of, you definitely have a couple of questions that are starting to pile up here. So I'll just start to get into them here. So we had a question. It said, expected expert charges for getting all of this together. Most should already have been assembled. How much can defense experts charge as a condition of his compliance?
That's actually a very good question. And I hope my defense friends are watching this. Because you're right. There are a series of opinions in which the experts have been ordered to produce this. So they pretty much should have this on hand. A cheap defense tactic. They're going to want to charge you an exorbitant amount of money for this. Again, you're going to have to go back to court. Just to give you an example, on this one expert, I'm not going to disclose his name, a court ordered him to produce the documents in the subpoena. He charged about $850 to do it. That's reasonable. In a new case, same expert, same disclosure. Defense lawyer tells me it's a $22,000 bill. Clearly, a year later, we don't have that much more records to produce or that much more financials to produce. So it is a tactic they will try to use to get you to not pursue it. You know, they can't beat you on the law. They'll try to beat you on the money. At that moment, you simply have to go back to court and say, Judge, a year ago, you charged $850. Now they want to charge $22,000. This is simply another attempt to avoid complying with your order. You have to gauge reasonableness here, and just be careful because that is a tactic they will use. And they're going to want to say, well, that's what the expert charges. The expert is going to go through his taxes and they're going to want to themselves redact it. Do the affidavit instead.
Gotcha. There's been a lot of there's been a lot of questions and in the chat with people who were asking for a copy of the subpoena. I don't know if that's something that
public record.
So yeah, we'll for everybody who's got that question, we'll definitely try to get it out either through Ginger or some other form.
One thing about the subpoena, Kyle, we have different ones depending on the specialty. For example, with neuroimaging, it's very specific as to what type of scanner the neuroradiologist uses. Also, what software they use to view the imaging, that can make a difference. And the reason why the scanner is important is because there's something called that. There's a great research group that has a research tool called the Human Phantom Project. And they've been really good at calibrating scanners all over the country to the same exact variables and metrics, so that regardless of where your client has a brain image, it can be compared to a research database. And I think we've talked about this in other webinars. I promise you, the defense expert isn't part of that Human Phantom Project, doesn't have the same software, and his scanners have different variables than the research Human Phantom Project. So that's another weakness he's going to have in his argument.
Gotcha. We do have a couple more questions, but I see Ginger just popped in, so we'll pause real quick because I think she wants to introduce some folks.
Yeah, I would love for everybody just to take a minute so that way you can meet Connor with Strategic and then also Kim from On Point Legal Nurse Consulting. They're just going to tell you guys a little bit more about what they do. And sorry about that. Connor, I see that you're here from Atlanta, Georgia. We are so glad to have you with us today. Thank you so much. Strategic, for those who do not know, they do amazing work over there. They're the only people that I know of that do the type of work that they do, and they do a really good job too. But Connor's going to tell you a little bit more about what they specialize in.
Yeah, thank you, Ginger, for that introduction. Kyle, it's great to see you, buddy. Hugo, nice to meet you. So we specialize in identifying ex-employees of your corporate defendants and then flipping them into insider witnesses or whistleblowers. And the way we do that is we produce what we call an EAL, or an ex-employee list. This is a list that contains the name, job title, tenure, and then confirmed contact information of these ex-employees. Right now, we're averaging 33 names per list. And once we source that list, the second step would be for us to launch our interviewers. We have 7 interviewers on staff that will call everybody on that list and just really find out what they know. You know, these ex-employees, they're detrimental to your defendants because they know the ins and outs of your defendants. They've seen that negligence firsthand, and they're willing to talk about it. Whether they're disgruntled or not, it doesn't matter. The information that they hold is a really, really powerful tool that you have at your disposal. So I have redacted copies of our ex-employee list, our EAL, that I would love to share if you're interested. This copy here is for a nursing home specifically, but we handle all types of cases all across the country. It's a really, really cool, useful tool. So if you're interested in that, my information will be in the chat below. Please feel free to call, text, or email me anytime. Thank you, Ginger.
Oh, thank you, Connor. And I believe like you guys have been helping out several of my attorneys on class class action cases too.
Yeah. Sorry, I forgot to mention that. We're also capable of identifying class reps for your class action lawsuits. So that's another really, really cool avenue that we can get in. So thank you, Ginger.
Pretty amazing work. We appreciate it. And I know you guys
Absolutely.
have been making a huge difference in a lot of these cases. I actually just saw Paul Luttrell a couple days ago here in Los Angeles.
Yeah.
It was kind of a nice surprise.
Yeah.
So you guys call Connor if you have any questions. Definitely save his number in case you need it later as well. Thank you so much, Connor, for being with us.
Thanks, Ginger. Thanks, guys. See ya.
And now I see Kim over at On Point Legal Nurse Consulting. I love their group. Oh my gosh, the ladies and the legal nurse consultants that work over there are just fabulous. And Kim has been with us for a while, and we're so happy to have you with us today, Kim.
Thank you. Just to tell you a little bit about On Point, we're a legal nurse consulting and expert witness firm. We've been supporting attorneys for over 25 years on any cases involving illness and injury. So basically, we have 4 programs to help you. If you find that you're getting bogged down with complex cases, or maybe you haven't used nurses in the past, the nurses in our consulting program have a lot of experience helping attorneys. And they do this through merit screens for med-mal cases, to timelines and chronologies that include our unique case analysis that outlines strengths and weaknesses, as well as identifies missing records, systems failures, red flags, and possible defense strategies. We can also identify the impact of pre-existing conditions and new versus aggravated injuries. Our nursing home and long-term care program assists with anything long-term care related, from a simple thumbs up, thumbs down merit screens that are done in a timely way, to specialized experts who are familiar with the standards of care and guidelines. Our program coordinator is a clinical geriatric specialist, and she has over 30 years in the industry. Our expert witness program, we can provide any experts in any specialty needed. They're all clinically active. So to the point made earlier, they're treating physicians and experts. They're located nationwide, and there's no fee to you for us to search for the right expert. For damages, we excel at quantifying damages with our life care plans and our medical cost projections, which is a lower cost option. And for non-economic damages, our pain and suffering analysis helps to tell the client's story. It quantifies what the client experiences: loss of pain, loss of freedom, loss of mobility. We pull that information out of the records for you to expand upon. So if this looks familiar, we can help. Our goals are to make sure you are not blindsided, to simplify the medicine and avoid surprises. If you have a case that you'd like to discuss, feel free to email me, and you can also submit your information right through our website. Thanks, Ginger.
I can't stop. I always smile when I see that photo, because I think about how many of us can relate to that picture, you know, with all the work piled up. So definitely working with you guys can help alleviate some of that. And we really appreciate everything that you do. So thank you.
Thanks, Ginger.
Have a great day, Kim, and we'll see you back
too.
again.
Thank you.
And now I'm going to go ahead and turn it back over to Hugo and Kyle. Lots of great questions are coming in. The next time that you guys see me, we're going to be doing a coffee giveaway. So enjoy.
Kyle, your volume's off.
All right. So, yeah, I just like to see if you're paying attention every now and then.
Good. I don't always.
All right. So I know that we're about halfway through some of this, so we've got some questions that stacked up. So let's maybe tackle those, and then we'll keep moving on. So there was a quick question. Could you please repeat the code number for the copyright law, if you don't mind?
Of course. It's the Copyright Act of 1976. That's the copyright law in the US, federal law. Section 107 through 118. Specifically, that's what allows you the copyright to exist. It's 106 and 106A that gives you the fair right use.
Good deal. Thank you, bud. We've got another one, similar track. It says, what is the title of section 7 of the subpoena?
I'll pull it up right now. I believe section 7 of the subpoena is going to be the bibliography. And that's going to be, give me your current CV, list of all your publications if you authored, any book chapters you've authored or you're co-authored. That's what section 7 is going to be.
Gotcha. Thank you.
And believe it or not, guys, plenty of times, don't even want to comply with that. Again, in one of the cases we recently had, we sent a subpoena. Defense lawyer's argument was like, Judge, they can Google him. They can find his CV there. I don't have to produce that.
So one of the things that, we were kind of touching on before we went to break was, kind of defense-focused testimony and talking about, the medical literature that they use to base some opinions. I guess, could you go a little bit deeper into, I know that they'll come up with, opinions based on literature and the stuff that you said you can poke a hole in, but do you find that there are similar tracks that, experts will take to, say your client's malingering, or say that, hey, this isn't real, that you found, hey, I can poke a hole in this?
Well, it's funny you brought up malingering, because that is the wheelhouse of a neuropsychologist or psychiatrist. Yes, malingering is a common defense. They will always team up with a neurologist and say, well, the reason is secondary gain. So one of the things is, when you do neuropsych testing, there's embedded performance measures. So these series of tests, and if you've ever done them, I mean, you want to kill yourself, especially for 2 days, have little tests within them to make sure you're giving full effort. And then there are separate tests, which are malingering tests, which themselves are problematic, and some courts have even excluded them. But I think most judges do allow it to come in because there is literature on this. But just so you guys can be well versed on this, the malingering literature is based out of a series of studies where a couple professors got together and said, okay, if I wanted to lie about my cognitive capabilities, how would I lie about it? And got a bunch of college students and listen, Kyle. So they go to Kyle when he's in college and say, listen, you want a research assignment? I want you to answer these 40 questions for me and answer them like you're trying to lie to me that you have cognitive deficits. And you do that enough times, that becomes the research pool for these malingering questions. So understand that first. And now the reason why I don't say brain injury, I say cognitive deficits, is because cognitive deficits are part of a brain injury. You can have them for other reasons too. And the field of neuropsychology is all based on whether you have cognitive deficits or not. Now whether you have the brain injury. A neuropsychologist cannot make the diagnosis. All they can do is tell you, yes, you have deficits. Now they can attribute them to a brain injury or to emotional behaviors or malingering. So be aware of that. Now, anytime your client does any kind of neuropsych testing, you're gonna wanna get the raw scores, the data, and the test. I will tell you this, you cannot get them yourself. There is an ethics rules between psychologists where they can be given to another neuropsychologist. So there will be a basis for that, and the defense will win those arguments. But your neuropsychologist or psychiatrist can take the information and can look at it, and they can see how far on the malingering scale they are or how close they are. Now, when they are close on the borderline, you have to realize there are other factors that can cause these questions to be answered a certain way. Physical factors, pain, emotional factors. And again, that ties in with what subpoenas require you. Give me all the literature and give me all the prior records you have. Because everybody wants to say, especially on the defense side, listen, he's got some deficits, as often happens in these cases, even the mild TBIs. Your neuropsychiatrist is going to test them and it's going to find deficits, and they're going to attribute them to the brain injury. The defense is going to test you as well, Kyle. And they're going to find deficits too, pretty much the same deficits, but they're going to attribute to something else, malingering, emotional things. The importance of the raw data and the scores and the testing is there is not one uniform across the country battery test given. It is and every even defense expert will put in the report, it is the responsible neuropsychologist's job to figure out which test to give and to interpret them appropriately. And I want to share with you guys, because this is out of an opinion in Louisiana, and it's a federal court opinion. And you will see what the court did regarding professional literature. And there was an objection to it saying it was costly and that testing materials and that it couldn't be produced. And the court agreed. Why? Because there's some ethics rules involved that if the testing material does get out, people can then try to figure out how to game the system. That's probably one of the best arguments defense can make, and they will make it in your case. However, your expert can get them. And that is exactly what the federal court did in this case. And they said, listen, the plaintiff is entitled to the materials. Their expert can review them. We're going to institute a protective order solely for these purposes. And the test materials can be disclosed to the other expert and no third parties and will be returned to the neuropsychologist at the end of the litigation. So that is the way you handle that. I mean, you will have to concede some things. You're not going to be able to get that outright. There's a good reason for it. And the problem is even your expert is going to say, I'm not giving you the test to the defense no matter what.
Powerful stuff right there, man. You did have another question pop up, bud. Mm-hmm. It says, can discovery requests demand that specific language in literature which defense expert relies on be disclosed?
So I don't think that your discovery language, I mean, you can put it in there, the specific language in the literature that you rely upon. That is going to be a little bit harder to enforce, because what they're going to say is this: listen, I relied on literature overall. Well, what specific part of literature? They're not going to tell you which sentence they relied upon. You can ask for it. I don't see a judge granting that. I think a judge would say they can give you the article, you go read the article.
I guess one of the things this draws me to is, you have somebody giving an expert opinion, and I hear often, the weight given to the treating physician's, testimony and opinions versus, the expert who's seen them one time. And I guess it makes me wonder about the gravity of those moments as it pertains to trial and presenting your case.
Correct. And that is one of the biggest concerns we have. And this is the reason why we do this, because there is, at least in Louisiana and in other jurisdictions, a jury instruction given to the jury that says the testimony of a treating physician is given greater weight. And it makes sense. There's a doctor that has seen him over a continuous period of time, observed the condition and treated it, as opposed to an IME that has seen him once for a few hours. That is a legal instruction. However, when you're trying a case to a jury, they will hear the instruction, but they will also hear the instruction that says, you give the weight of the evidence to who you believe has the greater weight. They will hear the instruction that says, just because somebody's an expert doesn't mean you have to take their opinion as a whole. You can take parts of it that, suit you or that you believe to be true. And what happens when the defense presents a very articulate, very well-dressed, highly educated expert? You have to be able to combat that. And that is why the opinions are there at the literature. And the courts have actually recognized that there is an inherent problem in experts because they can mislead a jury into believing that they are unbiased and that their opinions are the same as the treating physicians, although they are not.
Makes sense. All right, one more question, and then we'll let you get into it.
Before we go into that, let me show you a snippet from another opinion
Sure.
that I think is very critical, because it will show you the way courts kind of view this issue. And that's why I have these cases here ready to go, because this is kind of how you build your opposition. And you can look here in Section 8. This is a appellate court overturning a trial court's denial of this evidence coming into trial. And they say, unfortunately, the jury did not have the benefit of Dr. McDaniel's history as an advocate for the insurance industry. Perhaps if the trial court had allowed us to present the information to the jury, it could have reached the same opinion of Dr. McDaniel as expressed by this court. Where it says, this court is well aware of Dr. McDaniel's reputation for testimony that often crosses the borders into advocacy. By his testimony in the record before us, we will see it as a reputation well deserved. Moreover, his opinion is based only one examination of plaintiff. For that reason, it is entitled to less weight than that of a treating physician. And I believe that goes to your point.
Absolutely.
Now, that is a appellate court that has probably seen this expert parade around their courthouses, time and again. And for those of us who do litigation and who do it often, we know who the players are. You tell me who Kyle is. Oh, yes, I know. He always testifies to the defense. I know what he's going to say. 12 people on a jury think you're a nice guy.
Right.
Very articulate, very nice guy. I like him. And because these guys are paid advocates, experts, they're very good at testifying. Let me tell you, when the defense industry goes and gets an expert, they don't just go get any expert. They're going to get a guy who's going to look like the jury, who's going to be smart, who's going to be well reviewed, who is very articulate, who is a good presenter. And that is the advantage they have. Well, we have a treating physician, somebody who went to med school because he wants to treat patients, he wants to care after people, but he's not the best at giving the presentation in front of a jury. He's not trained like the defense expert to look at the jury every time answering a question and look back to the defense. So while you do have the instructions and juries do listen to instructions, this is the way you combat them being lured into believing that, this defense expert is actually an equally qualified and equally knowledgeable and equally unbiased expert.
Hit it right on the head. All right. Probably gonna botch this question a little bit, but it says I'm assuming this says in California CCP 2034 requires defense to provide all information at least 3 days prior to the expert depot. So no need for the subpoena, question mark?
It's a dangerous game. I would issue a subpoena no matter what. Because what's the timeline they give you?
3 days.
3 days. I mean, unless you're a fantastic speed reader and have nothing else to do, I believe when you're dealing with a traumatic brain injury case, and understand, these are multi-million-dollar cases. I mean, these are the $15, $20 million verdicts and settlements. 3 days for their expert neurologist, neuroradiologist, and neuropsychologist, I don't think is enough because, cheap defense trick. If I have 3 days to give you this, guess what I'm going to do? I'm going to give you 22 bankers boxes of article. Any piece of medical literature in my office, copy it and give it to them. Go fish. You want to be able to do this in advance. That's why I would still issue the subpoena. And Kyle, let me show you something else. And this is from a federal court.
Sure.
Because it touches on the point that we just addressed. And this is it. Now, there's a federal court in Tennessee. However, the concern remains the expert witnesses are in effect hired guns who, while educated and experienced in the field, are willing and able to hire themselves out to the highest bidder to provide opinions in favor of the hiring party. Such concerns have led courts to open the door to the opposing parties to obtain information from experts beyond that provided in Rule 26A2B, including financial information that would indicate their lack of impartiality and their bias in favor of the hiring party. And the reason why that's critical is, I don't know if we touched on this earlier, what the defense is going to argue is Rule 26 is the extent we have to produce. We do not have to go beyond Rule 26. And here you have the opinion. And if you want to write it down, if everybody ever needs it, it's 2009 WL 920337, Campos versus MTD Products. The defense is going to come in and tell you, we only are going to produce what the federal rules say we have to produce, and that is Rule 26. That is not true. There is case law out there, but if you don't know it, a federal judge might say, well, listen, Rule 26 only says this. And here's what Rule 26 actually says. It is very restricted and very limited. Rule 26 is a floor. If you notice, it's an initial disclosure. It requires a statement of the opinions, and regarding the compensation that is Roman numeral 6, statement of the compensation to be paid for the study and testimony in the case. It also asks you for a list of all the cases they've testified for in previous years. That is in a case-by-case basis. I think when you start digging into the relationship and the history, you're going to find a treasure trove of information. Just to give you an example, in this case we have, their neuroradiologist did produce his Rule 26 disclosures, and in the last 5 years, he's testified in over 70 cases. I haven't tried 70 cases in 5 years.
He's on the circuit for sure.
Exactly.
So one of the things, kind of going back to it, that I was hoping you could expound on, because, I just wasn't familiar with what was being said, was, you said opinions that are figured on results and not facts. And so that was something that I was hoping you could kind of articulate a little bit more, because it seems to be something that comes up.
Correct. And often enough what you find, and my defense friends watching this know this very well, that when they hire an expert, you're going to get the go-to expert, especially when it comes to brain injury, who's going to say, your client may have cognitive deficits, they're not related to the brain injury, the image findings are not trauma-based, there are a bunch of other things, and your client is perfectly fine, he can go back to work. In fact, the reason why he can't go back to work is not because he's hurt, it must be because he's malingering. They come up with the conclusion they want to come up with, and then it's go find me some research that backs me up. That is why you have these template reports. A lot of these guys, they can be sent a report over and over again. In fact, recently I did a settlement demand, and I told the adjuster ahead of time, listen, here's who you're going to hire. You're going to hire this person, this person, this person. And the report's going to say this, this, and this. And here's how I'm going to combat it. And I sent to them, and I sent them copies of prior reports. And a month later, she called me back and said, let's just settle the case. Because she called her lawyer, who they were going to hire, and she asked them, who are we going to get? And they said, A, B, and C. And she said, uh-huh. And the report's going to say this, and this? They are. Yeah. Thank you. I'm not spending my money on you. So, and that goes back to the literature. So let's look at neuroimaging. That's a really good example of this. Neuroimaging, you're looking for some kind of trauma to the brain. So you're looking for gliosis. Unfortunately, neither you nor I are trained, nor anybody in the jury is a trained neuroradiologist. You look at that imaging, you don't know what's what. Now as a jury, you need an expert to come in and explain what these lines and these marks mean. And it's very easy for the defense expert to come in and say, everybody's got those spots in their brain. That means nothing. Or, yeah, you look at that spot on the brain, they're saying it's trauma, but look, there's a study out there that says that smoking causes spots in the brain. That's what we need to study. Oh, there's a study out there that says that drinking causes spots on the brain. That's why you want to know which study they're relying upon. Each study has different parameters, different metrics. They look at the types of alcohol consumed, drug use, happens a lot, marijuana, cocaine. They want to say, well, drug consumption causes, abnormalities in the brain. Which study are you relying on, doctor? Because now you got to go back piece by piece by piece. The defense expert is trained to try to talk about possibilities. It's possible this happened. It's possible this happened. It's possible that happened. Well, yes, doctor, it's possible you might once tell the truth, but we know you're not going to do that. So you have to be able to go back one by one and say, in law, we deal with a more probable than not standard. And when you grab their literature and you say, this study you relied upon, the Rotterdam study required smoking cigarettes for 20 years, 2 packs a day with this level of nicotine. Isn't that true? True. Okay. How many do you smoke? I don't know. How often? I don't know. What's nicotine level? I don't know. So the one study you relied upon, you cannot tell me based on that study and the facts you have that it is more probable than not that that spot on the brain was caused by nicotine. True? Well, it's a possibility. Okay, let's talk about probabilities. If you do this right and you set it up by the deposition, these are your motions in limine. These are your Daubert motions. Because now you have a really good challenge. And I will tell you this, there are opinions out there in which courts have even hinted that if an expert or a portrayed expert is enough of an advocate, that is a basis to exclude him. So he may not survive Daubert. And let me tell you one thing, even if he does survive Daubert, when you get to trial and you voir dire this guy and you ask him all these questions, you destroy his credibility before they even start the direct examination.
I'm going to jump in with a couple of quick questions.
Go ahead.
First one is, do you have an expert of your own look at the literature, or is this something you do with yourself within the practice?
So there's two schools of thought on this. A lot of people say, that's why I pay an expert to do it. I'll give it to the expert, tell me where the bodies are buried, and my job is done. Well, it's still problematic for me because number one, you better have a whole lot of resources. And now your own expert is going to bill you a whole lot of money to be able to review this literature, digest it, and then give it back to you. From an advocacy perspective, those who go to a BOTA are taught that we have to present things to a jury who is not scientifically based and not law-based. Your expert is going to give you a pretty little report and tell you it's all bullshit and give you some really good scientific reason why that is. That doesn't do me any good. Because my point is, I need to understand the literature because I need to explain this to a jury who doesn't know what a longitudinal study is from a cross-sectional study, who doesn't know what a control group is. So I review the literature myself. That's why I say 3 days is not enough, because sometimes I may need 10, 20 days. I will go through each article. I don't care how many there are. I will make notes and I will read them until I understand them. Because once you're well-versed in his literature, you're on equal footing. As it was told to me today, doctors are really just technicians. They're not as smart as they think they are. What they do is they have training. And I don't even know everything about medicine. All I got to do is know all the articles they know for this specific issue.
Got it. Makes sense. Last question. How best to handle contrasting defense CME with treating physician when the treating physician has a pending letter of protection which will be paid out of the plaintiff's recovery?
So my first thing was I would try to motion eliminate that out. But if I can't, the way you contrast it out is on the basis that they have a medical license and that they have given you a diagnosis, okay, based on length of treatment, regardless of whether they're going to get paid or not. The diagnosis is there. And here's what you might want to be good at trying to build a wall for your expert with a defense expert. The defense expert is going to agree they're not a treater. They're going to agree it's not a doctor-patient relationship. And they're going to have to agree that when the doctor-patient relationship exists, the doctor is now exposed to a medical malpractice claim. And here's the linchpin. No doctor, well, very few of them, especially the IMEs, is ever going to testify that your treating physician breached the standard of care. Doctor, isn't it true that it is a breach of standard of care to provide non-elective treatment to a patient that is medically unnecessary? Yes. You're not saying that Dr. Kyle here breached standard of care, are you? No. All I'm saying is I don't see it that way. But he's got a physician-patient relationship with him, doesn't he? Yeah, he does. You don't, right? You can't get sued from practice. No, I can't. He could. Well, I don't know about that, but no, he did nothing wrong. Use that to your favor. Because now their own expert is saying this. So yeah, you got a lot of protection out there. He might get paid, he may not get paid. He's giving you the diagnosis anyway.
I mean, I hear it all the time with people who, make the argument, hey, doc, isn't it true that your opinion could be biased because, if there's no resolution to this case, or not a positive outcome, you don't get paid a cent.
I mean, not to give you a plug, Kyle, but I don't like lots of protection hanging out there. I would much rather the physician already be paid, and therefore he's got no skin in the game. I mean, if you got to deal with it, you have to deal with it. I mean, we're lawyers, we deal with the issues in front of us. But I will definitely say, if you can avoid it, I know that's one of the reasons why I've worked with you in the past, because that way I don't have a letter of protection hanging out there. So I've taken an issue off the table.
Got it. One more. Well, this is quick. It says, what's the citation to Campos' opinion on Rule 26?
Sure. I'll pull it up for you right now for the Campos opinion. That's actually a fantastic case. So I'll share my screen and you guys can see it. And I have to be perfectly honest with you, I cannot take all the credit for finding all this research. I have a fantastic law clerk, Ariel, and she's the one who actually found this great case. So your citation is 2009 WL 920337, Middle District of Tennessee.
Thank you.
No problem.
So, we got a little bit of time left. And so, one of the last things that we were kind of discussing was, undermining the science behind the expert opinions. And so I thought that that's a good thing to round out this discussion, because everything has been so literature-based and kind of how you take a real in-depth approach to your arguments.
Yeah, because look, the defense expert is always going to want to talk about it. Well, the science, the literature, the science, it's not exact. You can't prove it yet. Look, it happens with DTI all the time. If you do a mild traumatic brain injury case and you have DTI, you're going to see a motion to exclude it. And you're going to see the argument, it's too new. It's not ready for the courtroom. It's not scientific enough. It's not certain yet. So they're going to want to make two arguments. They're going to say that your case doesn't have the scientific weight, that it's uncertain, but they're going to want to come and say anything's possible. And because anything is possible, I can't tell you that you're right. The science goes to this. That's what the literature says. What do the studies show long-term? Okay, especially when it comes with brain injury. And the science is quickly changing. So the defense experts are going to want to rely on science that is probably from around 1993 or earlier, when they said, you cannot have a head injury unless you lose consciousness. Well, problem is, we know that's not true anymore. There's a whole series of studies, especially commissioned by the military after the Gulf War. And it showed that persons who did not lose consciousness could suffer a traumatic brain injury, which actually led the World Health Congress to redefine what a traumatic brain injury is. And nowadays, it's even being further redefined as a persistent cognitive syndrome. Because the most damaging part of a brain injury is the cognitive deficits. But it goes back to the point, when they give you a literature, I promise you, most of the literature they're going to use, pre-1993. And that's important. Because science and law are sometimes not that different. It is the same thing as if I cite you to a case from 40 years ago and it's been overruled and other courts have refused to follow it. That is why you want that literature. You want to wait, because when he talks on that stand about the literature and the literature, but the medical literature, and there's a body of medical literature. I mean, look, certain neuropsychologists that we always have against us in a case always talks about how the great body of medical literature was built on analyzing what happens with a patient at the earliest moments, and leaves it at that. Well, that's a cute statement. What literature we're talking about? Well, it's all pre-1993. But if you leave that door open for the expert, and he's a good presenter, he can stand in front of that jury and tell them, listen, well, the body of literature that has developed as a result of this, and there are hundreds of articles, and they all come to this conclusion. And the jury's like, oh, wow. And they're really, really good. I mean, they're going to have a stack of literature on the stand with them. Well, the literature. Well, you better have known what that literature is, because you can very well grab that literature and say, really? Let's look at this one. Let's look at this one. And you do 2 or 3. You don't go through all of them. But you basically break them down piece by piece. And now when he says the literature, the jury looks at him and says, oh, yeah, it's a literature guy again.
So, I know a lot of what you typically focus on has to do with traumatic brain injury cases, but assuming not everybody has those cases as part of their inventory, and it's a soft tissue case or a spinal cord injury case or whatever the case may be. I'm assuming a lot of the things that we're discussing today are applicable across the board for all types of cases.
They are. And look, as a lawyer, it's always a decision. If you have a small soft tissue case, I'm not going to recommend you issue the subpoena. It's going to cost you more to issue the subpoena than what the case is probably worth in settlement value. But if you have a catastrophic injury case and it's a multi-million-dollar case, you're going to have to issue a subpoena like this, and then you got to fight it, and they're going to file a motion to quash. You're going to have to oppose it, and then they're going to ignore you, and you have to go back to court. What you're doing is you're building your argument as to why you need all this information. And I will tell you, this is going to happen. It recently happened in a case. Their number one argument in front of the Supreme Court was, if you allow this opinion to stand, my experts are going to quit the case, and I will be prejudiced. Well, that tells you the importance of these documents, because these gentlemen know that if they produce this, their career may be toast. They won't have the same credibility in front of a jury that they've had before. So they will cry and say, our experts will quit the case if the subpoena is enforced. I'm sorry, you want to play a litigation game, you want to make a lot of money, these are the rules. Why? And then, so something else I forgot to mention, and as a secondary tactic, is this. After you get your subpoena granted, after you go through your appellate procedure, this takes time. This is not something you can do overnight. They're going to say, fine, we'll give it to you, subject to a protective order. Don't agree to it. Everything's redacted. There's nothing to protect, because what they want to do is limit it to this one case, so that in the next case, they can lie about it and it can't be used against them. Fight them in court. That is a tactic. And that is when you have the goods in these doctors and these experts. And look, it can also apply to a liability expert. There are plenty of cases. There's a case out of Maine in which it was a liability expert who always testified for the defense. Same argument. Get in financial bias for this. They made him produce everything. You haven't seen that expert around much more. Why? Because it's sort of, destroyed his credibility. But it's what we know on our side. It's what we got to be able to prove to a jury, because they don't know the difference between one expert and the other.
Yeah. You had a question to pop up. So it says, is there imaging that can objectively date the time of insult? But I'm pretty sure he's saying injury.
So, okay, so I'm going to try to answer as best I can. On a brain, I'm not a neuroradiologist, but I played one at a bar before, as you know. On a brain injury, there is nothing that can really date it as to when the injury occurred. I mean, you might have some bruising on the outside of the skull. You could have some swelling that's noticeable on CT. But once you do a 3T MRI, it is really difficult to date an injury. It's not like a stroke.
Yeah.
Where you can diagnose at some point and not the other. That's about as best of an answer I can give you. That is why you always want to document it with, any kind of pictures you have of the injury. Often enough, if you use a really good neuroradiologist, you want to get the films on the CT scan. They may have some swelling there that the radiologist missed the first time. Or, as we know it can happen, they might miss something between the slices.
Yeah.
Otherwise, you're not going to be able to date it.
Yeah. I was thinking about this as you're kind of talking, and it's one thing to kind of give snippets of procedural things and how you do it, and it kind of made me think about. I know you just had the case with Mr. Anderson, and so you think about things in practical application, as they come up. And I'm curious, that was that's a multi-million-dollar case, and so it makes me wonder, some of the challenges you maybe saw in there, and how you overcame it.
So yeah, this specific issue with Anderson had a lot of challenges. I'll tell you, they brought in a new team of lawyers into the case when we issued these subpoenas. Fantastic lawyers. I'm sure they're watching this because they're going to use this in court and try to say that I did this on purpose just to try to sideline their experts. I believe the argument was, if you don't like an expert's opinions, just run them out the case with overburdensome subpoenas. That's just them crying. Because the whole issue is, it's not about running the expert out of the case. It's about discovering the basis and bias information that they hold and being able to expose it, because at the end, we're trying this to a jury who doesn't know the difference. And look, they make great arguments. The reason why I know the way HIPAA works is because they make fantastic HIPAA arguments. The reason why I know the way the Copyright Act works is because they made fantastic copyright arguments that the courts were looking at me saying, well, isn't that a good point? And I had to be well-versed and prepared to say no, and here's why it comes in. And I didn't want to just simply rely on, well, other cases have allowed it. Well, other cases have allowed it, even in federal court. But if you want to look past those cases, here's the actual federal statute, and here's how we get into it. And once you can articulate to a judge a valid reason why your interpretation of law is correct on a discovery issue, you're more than likely going to get it. I do want to say one thing, and just a word of caution. Some states, for example, Michigan, has a rule where an expert's tax records are not discoverable. That is a positive rule. You cannot discover them in Michigan. So just know that if you're in Michigan, that is the rule. Also, if you're not in Michigan, you can always go back and say, well, Judge, if the legislature didn't want this discovered, they would have passed a rule like they did in Michigan.
Is there a way to figure out which states allow it and which don't?
So, of course, you can do analysis state by state.
Sure.
Like I said, I have a law clerk. That may be her new project, to go through all 50 states and find, which states allow it and which ones don't. My position is this: unless the state law says you're not entitled to it, there's plenty of federal case law from all over the country that allows you to get it.
Yeah. So I know that we've kind of covered a lot of ground today, and we're just about out of time. So I didn't know if there's anything we didn't cover, or we want to leave in closing before we kind of wrap it up.
I guess the one thing I would suggest to everybody is do the work ahead of time. Be prepared for a fight. It's going to take a few months. If you know anything about subpoenas, you got to serve them. Don't believe that they're going to give you all the information at the first shot. You have to be very aggressive on prosecuting them. Otherwise, they will give you the runaround. I have seen lawyers get the runaround on stuff. They will give you production, go through it clearly, make sure it matches your subpoena, and then keep pushing, because this is critical information that can make or break your case. Because the minute that you can prove your case with their witness, now it's uncontested. So just be cautious of that. And just know you're going to go back and forth to court plenty of times on this. They're always going to come up with a new argument and a new way to try to avoid it. And to me, that just shows the importance of all these documents have. Otherwise, they wouldn't fight me so hard for them.
This is great stuff. Great stuff. We really appreciate you giving us your time this afternoon and kind of diving into this topic. We know we've kind of been hitting it on all fronts, so we look forward to hopefully another installment with you. I know that there's probably 1,000 things you could come on and speak about. So again, we appreciate your time today.
Anytime.
Ginger, I see you up there. So we tried to keep it on time as best we could.
Yeah. You guys did a wonderful job. And thank you so much, Hugo. That was a fantastic presentation. I know that there's going to be a lot of our attendees who are going to want to reach out to you because they're going to have even more questions after this. So I definitely encourage everybody to call Hugo, to write him, as well as Kyle, in case you guys have anything else you want to discuss. I'm going to also email this to you after the webinar. And again, thank you to all of our amazing partners, with Fast Funds, On Point Litigation Consulting, and then also Strategic Relationships, and definitely HMR. And before we do this special coffee giveaway, somebody's going to win 4 bags of this freshly roasted coffee. Kyle, can you tell everybody a little bit more about what HMR does?
Yeah, sure. No problem. I think so as people hear week in and week out, we tend to be a part of a lot of these cases that are just complex. They tend to be catastrophic in nature. We are obviously in the business of medical funding and helping plaintiffs who don't have insurance, or they can't get what they need because the doctor won't hold a letter of protection. And so our company allows for those injured people to get the treatment they need. And it kind of takes away some of the arguments that came up in today's webinar about, how to handle a doctor who's holding a letter of protection and implied bias that comes with that. I think the fact that we do it nationally, we do it coast to coast, speaks volumes of kind of the resources we have, but we also like to put a very personal touch on it. We've got tons of people around the country who you can actually talk to in person that represent our organization, who, really know a lot about what's going on as far as medical funding. Everything we do is non-recourse. So, we really try to partner with the law firms we work with in a significant way. I think if I could leave everybody with anything, it's, they're not all perfect cases. In a lot of what we see, the cases have warts, there's risk. And we kind of pride ourselves on being able to take those cases. So if we can do, anything for anybody, as always, we're here to help. This, as always, is such a tremendous platform and thing for us to be a part of. So we really appreciate it, Ginger. Thank you so much.
Oh, the pleasure is definitely ours. We've had so much fun working with you guys. And again, your team is amazing over there, Kyle. Everybody that we've worked with, they're just really great. And it's been fun getting to know everybody. So thank you for helping us organize this webinar. And again, just bringing Hugo back, because it's always such a wonderful time with all of you. And awesome. Now, ready?
Yeah. The thing that actually everybody tuned in for. So today's winner is Ty Tyson with the Tyson Law Group out of Tampa, Florida. So congratulations, Ty.
Congratulations, Ty. This is fantastic.
I love that.
We're all over here cheering for you because you're going to love this coffee. It is absolutely delicious. And again, if you did not win today, don't worry, because there are 2 more chances that you can win this week. We have a really wonderful webinar tomorrow with John Romano. He's going to be talking about law firm productivity. And I am so excited to hear this. Very interesting. He's going to bring some information that we probably haven't heard yet. So I hope everybody goes to connectionology.com to sign up. And then also we brought in a brand new webinar on Thursday, which is going to be really good because you're going to be hearing a lot of information about our PowerPoints, about Zoom. It's going to be another just incredible webinar that you don't want to miss. Definitely pass the word along to everybody in your firm. So anyway, congratulations, Ty. We will be reaching out to you after the webinar. And again, thank you everybody for watching. We appreciate your time. And we hope you have a wonderful day, and we'll see you back again tomorrow.
Thanks, everybody.
Bye, everybody. Thank you.